Well, I mean, that's the whole question, is where do you draw the line? I mean, in the Lightstorm, and the Ryder versus Lightstorm Entertainment, one of the Avatar cases, Ryder, the plaintiff, actually worked with James Cameron for 2 years.
With James Cameron, one of James Cameron's junior development executives.
But ultimately it went up to the, I mean, James Cameron always kept a firewall between him and everybody for just that reason. But yes, he worked with Lightstorm, James Cameron's company, the company that released Avatar, for 2 years. Ultimately, it appears that they used a lot of his ideas in the movie, and the court did what federal courts had only done up till that point, but now state courts are doing now, which is just one by one deconstructed the similarities and then knocked them out one by one. And it's easy to do. It's a piece of cake. Anybody can do it. So anyway, so bottom line, the concept that studios or production companies are being vigilant to not steal, I personally think that couldn't be further from the truth.
So the development executive that was working with the plaintiff in the Ryder case left James Cameron's company and joined the Ryder company to help develop that screenplay project because he thought it was a good idea. The project, there was no, I don't believe there was any evidence that the project ever got to James Cameron. Landau and the other person that's the sort of operating officers at Lightstorm listened to a pitch, I believe, and rejected it. I don't think there was evidence that they'd read anything more specific than that. And in that particular case, I mean, you know, so many of these cases against Cameron, there's almost like you can almost cut and paste the fact pattern because Cameron, there's a huge amount of evidence for Cameron's developing that film independently enough to not be liable for idea theft and copyright infringement claims.
Well, the two main cases on the Avatar case, as long as we're talking about Avatar, were basically the Morawski case and the Ryder case. And both of these people, Morawski and Ryder, both had very close ties with Lightstorm Entertainment in connection with the development of Avatar, and they both lost. It's not so impossible to believe that James Cameron could take stuff from two people. Now, in terms of the other 5 cases, I have no opinion on them. I know one was by an artist. But it does not strain credibility to think that James Cameron might take some ideas from one person, might take some ideas from somebody else, and then use his own ideas in order to ultimately create Avatar. Yet Judge Morrow rejected one of them on the basis of independent creation, and then the Court of Appeals has recently rejected the other one on the basis of lack of substantial similarity. So.
And that's an interesting point. I mean, we're drifting into and including a discussion of idea protection cases, which are very different from copyright infringement. They basically involve contract, arguments, that there's an agreement to keep something confidential, or agreement to pay, or usually to pay someone if you use their idea. And there are, California has probably the most developed case law in that area, although New York has a very good body of case law in that area too, and in my view, New York's approach makes a lot more sense than California's. The things that don't make sense in California law about this area, one of them is that I think that first of all, I think the preemption argument, courts have missed the point. There's a strong federal policy that ideas should be free, and I think that suggests that federal copyright law, or federal policy, not copyright law, not Section 301 of the Copyright Act, but federal policy should very much limit claims that ideas, there's obligations arising from the use of ideas. One other thing that's really terrible about California as opposed to New York is that there's some case law in California that says an idea can be protected by implied agreement, even if it's completely non-novel, and even if it's not in no detail at all. It's completely not concrete at all. It's abstract, concrete. So taking that that concept, if that's true, and the courts have said that, if that's true, taking that to its extreme leads to an absurdity. I happen to be the first guy to meet with an up-and-coming filmmaker, and I say, I've got a great idea, do you want to hear it? If you hear it, if I tell you you're going to have to pay me and bring me on and all that, and he foolishly or she foolishly says, okay, and I say, I think you should make a buddy comedy. So does that mean that every time that person makes a buddy comedy, or maybe even a comedy in the future, somehow they owe me because of that agreement? Because it doesn't have to be novel, it doesn't have to be concrete. It can be vague and completely obvious. So I think that's a big problem with California's, and I think and then getting back to your point though, the Ryder case is important on another aspect of this, which is that one of the elements of these cases is that the defendant actually used the plaintiff's idea. That's the phrase they use, actually use. And there's been an issue for quite some time, going back to the Buchwald case, Coming to America at least, where the issue is at what level of similarity is necessary to show that, or to give rise to a supportable inference at least, that there is, that the defendant actually used the plaintiff's idea rather than coming up with it themselves or getting it from somewhere else. And the Buchwald case involved an express contract and had a very, very broad concept of what kind of similarities needed. All they said there was, it doesn't matter if there's any similarities, it was the inspiration for the Eddie Murphy movie, so that was sufficient to trigger the contractual obligation to pay for a movie based upon their material.
So just because the writer put the idea in the defendant's head means the defendant has to pay for it? Even if it's as broad as a buddy comedy?
Well, you know, California law says
no,
it doesn't have to be.
there's a lot of requirements. There's a lot of requirements. But let's take this example, for example. Jay, let's say you got a meeting with NBC, okay? And you were like, listen, I've got this great idea. It's basically going to be a talent competition, but you're going to have the three judges with their back turned to the performer, and they have to press a button to turn around when they like the performer, and then what you're going to do is you're going to bring that performer. Each of the judges are going to ask the performer to be on their team, whichever one's pressed the button to turn around, to be on their team, and then they're going to develop the performer for their final performance. Those are ideas, right? They're clearly. I mean, I don't think they're
somewhat specific, but yeah.
Okay, and let's say you propose this idea.
Are they red chairs? Are they red chairs?
So you propose this idea. You propose this idea to an executive at NBC, right? And they're like, you know what, Jay, great idea, but it sounds too similar to American Idol. Whatever, we pass. You're sitting and you see The Voice, and there's the three judges, and they press the button, and they turn around, and then they get them on their team. How would you feel about that, Jay? Do you think NBC owes you any money?
Well, you know, that's a hard hypothetical. You know, that there are specific details that may or may not be kind of commonplace in the reality show genre.
Okay.
I'm not a fan of reality shows, so I'm not sure how many of them involve judges who select their proteges, you know, blindly. I don't know if there's a lot of shows like that or not.
Okay.
But you know, that said, if you get a sufficient number I mean, reality show formats are very difficult to protect. There's very little that's protectable about those in the United States. Other countries, there are format protection systems to deal with formats like this. In fact, formats are extremely valuable properties. The shows companies like NBC, that if they own the format, will make a large amount of money by licensing local foreign productions based on the format. So there's something valuable there, and maybe even the studios think it's intellectual property. But you know, at what level does that? I mean, first of all, the circumstances surrounding my telling NBC this would definitely be important, right. And we just forget about that for the moment. Let's assume they understood that I was there to sell them something.
Okay.
And then I think that if the level of ideas was that concrete, was that I'm not sure how novel it was, how obvious it was. If it's obvious, I'm not sure I would say that they owe me anything. If it was non-obvious and very concrete and detailed,
but
I think I might have half a chance at succeeding on a contract.
I mean, isn't everything non-obvious until it becomes obvious, or everything obvious until it becomes non-obvious? I mean, in other words, the idea of pressing a button so that the chairs turn around, I mean, that's not a brilliant idea or anything like that. It's pretty commonplace. But God, it's been working for The Voice, right?
I think it's the people in the chairs that are really doing the job.
Okay, yeah, it's the people in the chairs, no question about it.